Good afternoon, everybody. I hope that you can hear me. My name is Amanda Paul, and I'm a senior policy analyst in the European Policy Centre's Europe in the World programme, and I'm responsible for the EPC's work on Ukraine. On behalf of the EPC and on behalf of the mission of the United States to the EU, I would like to welcome you to this transatlantic policy dialogue, which is going to be discussing how Russia can and must be held accountable for war crimes and crimes of aggression in Ukraine. Russia has been carrying out barbaric crimes against the people of Ukraine since the first day of its full-scale invasion of the country. It purposely targets civilians and civilian infrastructure. In fact, Russia has been doing this in Ukraine since 2014, following its illegal annexation or occupation of Crimea and self-instigated war in eastern Ukraine. Unfortunately, Russia has never been held accountable for any of the crimes that it has committed, whether that be in Ukraine, in Syria, in Chechnya, or Georgia. The Kremlin believes that it can do what it wants and won't have to pay any price for that. I think it's beyond time for Russia to face justice. Personally, nothing would give me greater pleasure than for Putin and his cronies to be guests in The Hague. Now, with us to discuss these issues today, we have a really stellar panel of guests. Firstly, we have Andriy Kostin, who's the Prosecutor General of Ukraine, Anton Korynevych, Ambassador at Large at the Ministry of Foreign Affairs of Ukraine, Nils Behrndt, who is Deputy Director General at DG Just in the European Commission, Roeland Böcker, Ambassador, who was responsible for accountability in Ukraine at the Ministry of Foreign Affairs in the Netherlands, Oona Hathaway, Professor of International Law at Yale Law School, and last but certainly not least, Maria Kurinna, who works as International Advocacy Manager at the Human Rights Center, ZMINA, in Ukraine. Just a word to the audience, if you would like to put a question, please either type it into the Q&A box or click on the hand icon. I'm pretty sure you're all very familiar with that now. And I would really like you to start to put your questions or your comments really early on in the discussion so I can put them to our speakers as we go throughout the conversation. I would like to start with you, Mr. Prosecutor General, with my first question. The whole of the civilized world has followed the situation in Ukraine. We know that Russia started its aggressive policy regarding Ukraine, not in 2022, but much earlier in 2014. But precisely on 24 February 2022, the full-scale invasion of Ukraine took place. Can you describe the situation in Ukraine after this date?
Thank you, Amanda, for your questions. Before addressing the issues you have raised, I want to extend my deep condolences to Turkish people and the Turkish government due to tragedy that struck as a result of major earthquake in southern province of Maras. We wholeheartedly wish the success of the rescue and recovery teams and speedy recovery to the injured. Turning to our today's discussion, let me express appreciation to the EPC mission of the US to the European Union for organizing this event, contributing the discussion regarding political, legal, and human dimension of the war in Ukraine. I'm also grateful for your nuanced formulation regarding the Russian aggression against Ukraine. Indeed, the military intervention of 24th of February 2022 is a continuation of tragic events from 2014, when Russia illegally occupied and annexed Crimea, as well as established military occupation of the eastern regions of Ukraine. The 2014 events are subject matter of consideration of the first group of interstate cases litigated by Ukraine against Russia before the International Court of Justice and European Court on Human Rights. Russia's war of aggression has no analog in international relations since the Second World War, with its barbarism, brutality, and disrespect to international law-based order. The biggest concern for us is that from the first day Russia has been engaged in hybrid urban warfare, whereas civilian population becomes not only casualty, but the primary target of the attacks. I believe you all remember indiscriminate shelling of the cities full of civilian population and months-lasting sieges that created dire humanitarian situation. Unfortunately, these practices still continue coupled with the acts of terror and intimidation against the civilian population. Deliberate targeting of critical civil infrastructure aimed at destruction of power supplies, causing electricity blackouts, heat and water supply disruptions, is a widespread practice that has started from October last year. Even last week, we have witnessed Russia rain missiles against cities. There is no doubt in our minds that this deliberate targeting is part of the terrorist policy to intimidate civilian population and paralyze Ukraine. Another brutal dimension of the war is treatment-related crimes, whereas Russian army or proxies and organized armed groups under its control torture and ill-treat detainees, carry out sexual violence against vulnerable individuals like women and children, and unlawfully confine them in inhuman conditions. Discovery of mass graves, tastament of extrajudicial executions is often the evidence we witness in deoccupied territories. Third biggest category of crimes is related to Kremlin drive policy of denial of Ukrainian identity, with horrific attempts aimed to change demographic situation in temporarily occupied territories through forced deportation and transfer of civilian population, screening infiltration camps, and forced adoption of Ukrainian children in Russia. Last but not least, Russian army engaged extensively in looting and pillage in temporarily occupied territories without any exception, even in restricted areas in the vicinity of nuclear facilities.
Thank you very much, Prosecutor General. I'd just like to come with a follow-up question, if I may, related to the investigations that are going on. I mean, can you describe to us the scale of the investigations that you're now looking at, and what are the main crimes and the nature of the crimes that you're examining and focusing on? I mean, and also what are the key challenges to your work?
Currently, my office leads national investigation in three primary directions: crime of aggression, crime of genocide, and war crimes. Undeniably, it is the waging of aggressive war that often leads to war crimes and other mass atrocities. Therefore, it's rightfully described as the supreme international crime, within itself the accumulated evil of the whole. It's a quote from Nuremberg Tribunal. What is the crime of aggression? I think the facts speak for itself. As an evidence of this crime, Putin, as the president of Russian Federation and as the supreme commander-in-chief of Russian armed forces, ordered unprovoked and unjustified military intervention in Ukraine on 24th of February last year, and up to now continues this illegality. This is a leadership crime that clearly precedes other international crime. Therefore, the primary suspects in the criminal proceedings are the military and political leadership of the Kremlin regime that planned, instigated, organized, and implementing the act of aggression. Let me briefly address the crime of genocide. The widespread and systematic pattern of attacks against Ukrainians due to their identity has nothing to do with the combatants' engagement in armed clashes. It's part of Russia's criminal policy in support of so-called de-Ukrainization, directed towards subjugation of a local population by eliminating dissenting voices. For that purpose, the Russian authorities designed and implemented a system of filtration camps, whereby residents of a particular area would be screened before being permitted to remain in the occupied territory or forcibly deported to Russia and/or Belarus. An estimate for forcibly transferred or deported population is up to several hundred thousands. We have established fact of forced displacement of around 16,000 children in course of our criminal proceedings, often followed by forced adoption processes in Russia. Undoubtedly, the highest number of incidents relate to war crimes, violations of laws and customs of war. We have more than 66,000 registered incidents. The war crimes range from indiscriminate shelling, extrajudicial killings, torture and conflict-related sexual violence, to unlawful confinement and pillage. Unfortunately, scale of war crimes is truly devastating. The death toll among civilians is more than 9,000, including more than 460 children. Number of wounded civilians topping 12,000, including more than 900 children. And our primary objective is to ensure accountability for international crimes by effective investigation and prosecution. Doing so, we serve the interest of justice while acting in best interest of victims and survivors. Therefore, our investigation is focused in structuring the chain of command in order to identify those who planned and ordered commission of the international crimes, rather than satisfying ourselves with the investigation and prosecution of the direct perpetrators, ordinary soldiers. Let me briefly address the challenges we face in investigating international crimes that are complex in their nature and dimension. First and foremost, it's the access to evidence in places with active conduct of hostilities, or that still remain occupied by Russia. It creates security challenges for law enforcement personnel. Timely and authentic fixation of evidence is key to a successful prosecution. Consequently, we have learned and started use of OSINT materials in course of criminal proceedings, and we are grateful to the players on the ground that are helping us with relevant techniques and applications. Second, face identification of the perpetrators and linking crimes to the commanders responsible for specific military operations and assaults. As a response to this, we have compiled the military expert group that is qualified to advise prosecutors on rules of engagement, chain of command, and weaponry. Equally important is our ongoing intra-institutional and international cooperation in identification and tracing of singular perpetrators. And third, lack of crime-specific equipment, exhumation of mass graves, or damages to the environment being some of the examples. Again, we are grateful to our partners for securing assistance in this direction.
Thank you, Prosecutor General, for this very, I think, detailed assessment of the situation and the challenges that Ukraine is facing. I want to move now to your colleague from the Foreign Ministry, Anton Korynevych, for him to perhaps elaborate further in terms of the job that you're doing. I mean, if I understand correctly, or if I remember correctly, Ambassador, you're tasked with progressing for the special tribunal to be established. Can you take us through the things that you're now doing? What are the priorities? How far have you got over the last several months? Or what are the barriers that you're facing in this respect? I mean, where are we in terms of setting up this tribunal?
Thank you very much, Ms. Paul. Good afternoon from Kyiv, dear colleagues. It's a pleasure to be here today with you. And of course, it's a pleasure to talk after our Prosecutor General, Mr. Kostin. So as you know, the issue of accountability and justice is one of priorities for Ukraine. And it is number 7 in the peace formula plan suggested by President Volodymyr Zelensky. And moreover, justice and accountability is one of the main tasks of Ukrainian diplomacy for this year, for 2023. As Mr. President tasked the Ukrainian diplomacy, the Ministry of Foreign Affairs and our ambassadors in the end of December last year. And of course, when we talk about accountability and justice, we talk about comprehensive accountability system, meaning that there are no gaps, no loopholes in that accountability system, and that responsibility for all the international crimes mentioned by Mr. Kostin is ensured and secured. Whenever we talk about war crimes and crimes of genocide, we know that there are both national proceedings and there are international possibilities to get the perpetrators of these crimes on the bench. In particular, the International Criminal Court providing the investigation of the situation in Ukraine. But whereas we are talking about the crime of aggression, the supreme international crime, the crime which really in our situation is a cause of all that dozens of thousands of war crimes committed in the territory of our nation. So we understand that the crime of aggression is the reason for that. And unfortunately, with responsibility for that particular crime, we do have a gap, meaning that national proceedings are very important, but they have some issues in relation to the highest representatives of political leadership of the Russian Federation, in particular the issues of immunities. And also when we talk about the international level, we understand that the International Criminal Court currently, under the current circumstances, cannot exercise jurisdiction over the crime of aggression against Ukraine, because Russia is not a state party to the Rome Statute. Russia has not ratified the Kampala amendments to the Rome Statute on the crime of aggression. And also the United Nations Security Council is unlikely to refer the situation, if I may say so diplomatically, is unlikely to refer the situation to the ICC. That is why, if we are talking about the accountability for the crime of aggression, we need to establish an appropriate judicial mechanism, which currently does not exist. We need to establish it. And in order to establish it, we need to get support, maximum broad support from our partners, from our friends, from international community. And this project of the Special Tribunal for the Crime of Aggression against Ukraine is in work since the end of February 2022. And we got, I think, a rather nice results as of now, in particular on both political support track and legal track. As of now, we do have 5 resolutions of European Parliament. In particular, one of them is a specific resolution dedicated to the support of the establishment of the Special Tribunal, 6 resolutions of Parliamentary Assembly of the Council of Europe, resolutions of Parliamentary Assembly of NATO and OSCE, resolutions of several national parliaments, conclusions of European Union's Council of October and December 2022, which either support or take this work forward in order to get the accountability for the crime of aggression against Ukraine done. And I'm sure that we are on the right path. And the very good example of the results which we already achieved was the Ukraine-EU summit last Friday, with the results of which we are very happy when we talk about accountability. And paragraph 12 of the Ukraine-EU summit joint statement, which actually says about the need to ensure accountability for the crime of aggression, in particular through the establishment of appropriate judicial mechanism, and which says about the need and decision which is taken to establish in The Hague the International Center for Prosecution of the Crime of Aggression, which would be the first international effort in relation to real investigation of the crime of aggression after the Second World War, and which is a first step in order to coordinate the investigation of the crime of aggression against Ukraine, get the relevant evidence, secure them in order for us to have the investigation, which then our prosecutors from Mr. Kostin's office, prosecutors from, we hope, further future special tribunal will be able to use in order to prosecute this crime. As of now, we are moving from this track of political dimension, from getting political support, to more legal and technical track to get the understanding on legal track how to move forward, to get the answers to the most important legal questions. In particular, that is why we gathered a core group of states, which literally every day enlarges. Every day, Friday, Monday, we hope that maybe tomorrow some more states will join the core group. And it means that more and more states join the process of getting the accountability mechanism for the crime of aggression against Ukraine done. And by saying this, we hope that the core group will be an important platform, and is already an important platform, in order to establish accountability for the crime of aggression and to find the solution by which the tribunal, the appropriate judicial mechanism, will be established. And I think that the overall result of all this, our efforts and endeavors in this calendar year, is that the question is not if, the question is how. And of course, we are grateful to our European Union's colleagues and partners for their support in these efforts, in these endeavors. We are sure that we will make these mechanisms happen together with the support of our international friends and partners.
Thank you very much, Ambassador, for again a very comprehensive intervention. It seems that Ukraine and you personally are moving very quickly towards the establishment of this special tribunal. I'll come back to you again a bit later, but I want to now turn to our colleague from the Commission, from DG Just, to Nils. I'd like to ask you to share your views and explain now what are the priorities of the Commission of DG Just, and perhaps in relation Eurojust on this issue vis-a-vis the investigation of war crimes in Ukraine today.
Thanks a lot, Amanda. Yes, happy to share, and perhaps let me start by congratulating the Ukraine prosecution offices, but also let's say all the other Ukrainians that are working in incredibly difficult circumstances to fight this immense extent of crimes that we are seeing in the context of the war in Ukraine at the moment. It's really amazing to see that work going on. The Commission tries to support Ukraine, and clearly, let's say, our overall objective is, as has been said today repeatedly, to ensure full accountability. That's a question of justice. We need to get there. But at the same time, it's not only a question of retroactive justice to try to bring justice to those atrocious situations, but at the same time to prevent as much as possible further crimes from happening. At the moment, the Prosecutor General mentioned that at the moment, this war crimes website of Ukraine is registering more than 66,000 war incidents at the moment. The numbers are still rising, 1,000 more every week, more or less, at the moment at least. So the extent of the crimes is really horrible. Therefore, operationally speaking, the most important objective from our side, from the Commission, is to support Ukraine as much as we can, because Ukraine is in the driving seat. You are in charge of most of the criminal investigations, and that's why, together with our Ukrainian partners, we try to support as much as we can. For example, the challenges that the Prosecutor General mentioned, we are in touch with our Ukrainian partners just to list what kind of precise needs do you have. When you need an IT server for the website of War Crimes UA, when you need protective equipment, when you need experts to go on the ground, we try to be in touch to understand what are the precise needs of the Ukrainian prosecutors, police services on the ground, and then discuss with partners inside the Union, but even with other international partners, how those very concrete needs can be fulfilled. That's really the most important one. And there we have different mechanisms in place to make sure that we are getting those kind of needs and then responding to them. Of course, and that's the second point, at the same time, we try also to coordinate the ongoing investigations that are happening in a couple of member states. We have several member states that have 14 member states overall in the Union that already have launched criminal investigations because of the crimes that happened in Ukraine. Again, secondary to the prosecution done in Ukraine, but for reasons of personal, territorial, or universal jurisdiction, 14 member states are prosecuting crimes that happened in Ukraine. And several of them joined a so-called joint investigation team, where they work very closely together at our union agency, which is called Eurojust, which provides support to ongoing prosecutions. 4 out of those 6 member states, by the way, even have the crime of aggression in their national laws, as Ukraine has. So let's say those crimes that we are coordinating concern the crime of genocide, war crimes, crimes against humanity, but also crime of aggression, the leadership crime that the Prosecutor General and also Ambassador Korynevych already mentioned. Very important also that we are using together with international partners existing structures like the International Criminal Court. Again, very important because the ICC is also investigating, obviously, the situation in Ukraine. 43 states referred the situation to the ICC in March last year. And the ICC has opened investigations on war crimes, crimes against humanity, and genocide. Indeed, at the moment, as the ambassador pointed out, the ICC is not competent directly to look into the crime of aggression. They can look at elements that concern crime of aggression, but cannot prosecute them directly. So let's say those are the operational issues we are looking at. In the, let's say, long-term ambition to come as fast as possible to full accountability mechanisms also on the crime of aggression, we are reflecting together with our Ukrainian and international partners how to move forward. The decision on what kind of format to go for, we might come back later in the discussion, but indeed what in our point of view is very important is that the message that there will be full accountability up to the highest level has to pass soon, and in that perspective we have to immediately start collecting the relevant evidence. And that's precisely why, as Ambassador Korynevych already mentioned, last week, together with our Ukrainian partners, we announced the setting up of, let's say, a body that would help to collect evidence on crime of aggression. So about the leadership in Russia, about the crimes committed in Ukraine, collecting evidence, then to hand it on once the decision is taken in which form to take this forward, then to make sure that this evidence can be passed on, but to start collecting the evidence now and also sending the message that there needs to be full accountability.
Thank you, Nils. I want to move straight on to Roeland now, if I may, keeping it in the EU dimension, to follow on with this discussion. I mean, the Netherlands has come out very strongly in support of a special tribunal, both at a government level, but also passing it in the Dutch Parliament. So I would like to ask you now, because you've been working on this topic for a long time, I mean, justice issues, I mean, what are going to be the priorities of the Dutch government moving forward in this respect? Are you going to be able to also play a role in perhaps cajoling other member states who perhaps aren't that favorable to the establishment of a special tribunal to actually get on board? That would be the first question. And the second would be, maybe you could elaborate a bit more on this new Center for the Prosecution of Crimes of Aggression in The Hague that was just established. I mean, what's its legal base going to be for its operation? And if there's, prosecutors or judges or whatnot going to be there? I mean, excuse me, I'm not a legal expert. Can you explain from where these people will come? How will they be selected?
Thank you very much, Amanda. I hope you can hear me. Good. Let me first of all apologize for being very late. I had major connection problems, which is something that happens to me all the time, I'm afraid. But this time was particularly difficult for some reason. Anyway, I'm here. It means I missed the first two interventions, much to my regret. And I run the risk of repeating things that have already been said by others. Nevertheless, let me just share a few thoughts from the perspective of the Netherlands. And Amanda, you said I've been working on this for a long time. I'm afraid that's not the case. No one of us has been longer on this particular case, more than a year, of course. I do have some previous experience in issues related to international crime and international law, for sure. First of all, why, as the Netherlands, are we active? Why do we take a profile on this issue in the first place? Well, obviously, first of all, because there is nothing more important at the moment, I would say, in international politics than this particular issue: how to deal with the war in Ukraine, and particularly accountability for what's happening there. And accountability is the umbrella under which we labor here in the department that I work for. The answer to the question is more particularly that as the Dutch government, we are obliged under our constitution to promote the development of the international legal order, and this already gives a good motivation to be involved with what we do in relation to the war in Ukraine, and therefore we have also agreed to with Ukraine that we would take the lead in point 7 of President Zelensky's peace plan, which is called restorative justice. So we want to be involved as much as we can in that particular issue. How do we operate that search for restorative justice? First of all, of course, by supporting Ukraine itself, and I believe this has been said by the previous speaker, that justice should preferably be found within the national legal sphere, but it's obvious that that will not suffice under the current circumstances. And that said, I immediately jump to the International Criminal Court, which was not created for nothing. Of course, it has and should have a major role at the international level in securing justice and accountability in relation to the war in Ukraine. So supporting the ICC, I would say, is pivotal to our policy. We have expressed not only political but also financial support to the ICC after the start of the war. We have contributed by sending forensic teams to Ukraine twice in 2022, and there will be 2 more such teams in 2023. These teams conduct investigations, they secure evidence, they record witness statements, they conduct DNA tests, they collect digital information from cameras and computers, and so forth. So we hope and we trust that this is an important contribution to primarily to the work of the ICC. Another element I'd like to mention in this regard is an upcoming conference on the 20th of March by the Justice Minister, organized by the Justice Ministers of the Netherlands and the United Kingdom, also in support of the ICC. And we also use every opportunity, and I would use this one as well, to encourage Ukraine to accede to the Rome Statute, and I am sure that this process is being engaged upon already by the Ukrainian authorities, but we believe it is essential that Ukraine joins the family of states that support the ICC. We also know, and it has been said by the previous speaker, if not by all the previous speakers, that the crime of aggression in relation to the ICC mandate is problematic, that it is not in the foreseeable future possible for the ICC to prosecute that crime, and in that light, the relevance of the International Center for the Prosecution of the Crime of Aggression, which also, Amanda, you have asked about, is very important as well, perhaps in a somewhat longer term, as the creation of a special tribunal, whatever form that may take. As far as the IPCA, as it is now called, the International Center for the Prosecution of the Crime of Aggression is concerned. You have probably all heard the President of the European Commission last week announced that this center will be created and located at the Eurojust offices in The Hague. Coming to your questions, Amanda, I'm afraid I cannot yet in detail, if ever that was my task, describe what exactly it will look like. But the way I understand it is that there will be prosecutors coming from Ukraine, supported by staff, probably by international staff, I assume. I cannot possibly say at this stage how many people we are looking at, but they would work in the framework of the already existing joint investigation team, which is supported by 6 member states, the Netherlands not currently being one of them. And they will collect evidence, share evidence, use the facilities that Eurojust has, and in doing so prepare for any future jurisdiction, whether national or international. In fact, for national jurisdictions, that's already what they are doing. Then one step further would be the creation of a special tribunal. You will be aware that the Minister of Foreign Affairs in December has expressed his interest to the interest of the Netherlands to be host state for such a tribunal. There are important conditions, most notably, I would say, sufficient political and financial support at the international level. I believe that should be stressed. Another such condition is that a new tribunal does not interfere with the work of the International Criminal Court. So these two are very important to bear in mind. If you ask about what the tribunal should look like, I can only say that as the Netherlands and as the projected host state, we have not yet taken a position on our preferences. We know that there are roughly two alternatives. I know that there are more, but in order to keep it slightly manageable, one being a truly international tribunal with involvement of the United Nations, the other being a hybrid tribunal based on Ukrainian law with any international element. So this is more or less what the discussion is now concentrating on, and all I can say is that we have not yet at this stage taken a position other than expressing our interest, our availability to act as host state, no matter what the final outcome would be. Then finally, I am coming to a close. I'm probably already speaking too long. We are in contact also with our Ukrainian partners about a possible claims register, and it's possible location in The Hague as well. This has not yet been decided. It's being studied at the moment, and we are aware that this is an issue that needs to be concluded with some speed. So that is an overview of the most important pieces that we are currently pursuing. Maybe one other one, you may be aware that on the 14th of July, we had a big accountability conference on Ukraine here in The Hague. This has sparked the initiative of creating a dialogue group of member states getting together to coordinate all the efforts that are going on, and we know there are many, and I mentioned a few. This dialogue group is still in statu nascendi, if I may call it that, but we also here we expect a quick further developments in the sense that the dialogue group will get together and start doing its coordinate work. I can leave it at that, and of course I'm available for any questions you may have. Thank you very much.
Thank you, Roeland. And I want to again stay with the topic and move to you, Professor Hathaway. I mean, you're a law professor. I mean, you've written extensively, I think, on many of these issues. I mean, including a recent paper that I read in Foreign Affairs on Russia's crime and punishment. Which I would recommend actually to everybody to read. I think it's a very good analysis of the different options. So it'd be great to hear from you. How do you see the establishment of this special tribunal, and which format would be the most likely? I mean, which body to establish it under? And the second point would be about the actual position of the United States. I mean, if my memory serves me correctly, the US had originally said it was something that could be done under the ICC, but as we've all heard, and I think is well known now, this is not going to work. So is there something else that would the US support such a tribunal under a different format?
Great. Well, thank you so much, and thank you for the opportunity to speak here. And I really appreciate the remarks of the other panelists, which have been really illuminating. So I will speak to the issue of sort of which of these approaches, because I think that's one issue we haven't really covered fully, and sort of what are the stakes between these different possibilities. And I think it's right, the way that Roeland laid it out, the kind of two key proposals that are kind of on the table right now are the possibility of creating a truly international court. That would be created by an agreement between the United Nations and Ukraine, on the recommendation of the General Assembly. As many have already said, Security Council is highly unlikely to participate in the creation of a tribunal, so we'd have to rely on the General Assembly. We've already seen the General Assembly pass several resolutions related to condemning Russia's aggression in Ukraine. So it has been activated already several times in the face of inactivity by the Security Council. So the idea would be that it would be created through an agreement between the United Nations and Ukraine that would establish a truly international tribunal, an international court that would have the capacity to try anyone that potentially has committed the crime of aggression. So that's one possibility. And where that would be housed would be up to negotiations between Ukraine and the United Nations, but seems likely it would be in The Hague, just for convenience sakes, because because now the prosecutor's office is there, and also because the International Criminal Court is there, and there would have to be very close coordination between the court, the International Criminal Court, and this new special tribunal. A second proposal that's on the table is this idea of creating it through a hybrid tribunal. There are lots of different versions. Hybrid doesn't tell you that much. It just tells you it's hybrid between international and domestic. It doesn't tell you, is it primarily international? Is it primarily domestic? Who are the judges? Exactly where is it housed? And those details have not been firmed up by those who support this idea of doing a hybrid tribunal, but to the extent that they have been, people have been talking about it being a hybrid tribunal created within the Ukrainian legal system. Now, there are advantages to this, which is the Ukrainian legal system, as we've already heard, has been activated in lots of ways, already trying many of the crimes that are happening in Ukraine. Ukrainian law does provide for the crime of aggression, and so there's a continuity there. But there are major downsides of this approach. One major downside is that under the Ukrainian constitution, there's a prohibition on the creation of special courts. And there's real concerns that creating a special court, even with international support within the Ukrainian system, would run into constitutional issues. I wrote a couple of pieces for Just Security with a Ukrainian lawyer, which reviews these issues, and I can put that piece in the chat in case that's helpful for readers. A second big concern about approaching it through a hybrid model, particularly one that's housed within Ukraine, is that the very top leaders would be off the table. So personal immunities apply within foreign domestic courts. So foreign domestic courts cannot try the leaders of other states. They can't try Putin, they can't try Lavrov, they can't try the people most responsible for this crime would be off the table. And I think for many people, that is, for many, that is really that's a hard step to allow. This court, the whole point of this court, in many ways, is to establish the fundamental illegality of the planning and execution of this war, and to take the people who are most responsible for that off the table for the prosecution. Seems to really undermine the purposes and the meaning of this court, because ultimately what this court is intended to do is not only to try particular Russian leaders who've been responsible for the crime of aggression, but also to send a really powerful message that this war is fundamentally illegal and indeed criminal, and to let Putin off the hook for that seems deeply problematic. Now, if that's the only way forward, there are many people who are going to support that. For lots of reasons, legally, that's not the only way forward. It's a question of politics and what states are going to get behind. If they're willing to support the creation of a truly international court, that would really send a much more powerful message, and would allow a much broader and more effective court system. Last thing to mention is that while the Ukrainian courts have been remarkable, I mean, truly remarkable in the work that they've been doing in the midst of this war, in prosecuting Russians for the various crimes that they've committed, the crime of aggression in particular has a relatively light sentence, at least from international perspective. And the crime only allows a fairly short sentence of 10 to 15 years for the crime of aggression. And so, again, thinking about the fact that this is, as many speakers have mentioned, the mother of all crimes, without which the rest of these crimes would not exist, there's a concern that relying on domestic law, which provides for a relatively light sentence, wouldn't send the message that those who support bringing those to account or responsible for the war want to send. So I'll leave it there and happy to take follow-up questions.
Thank you, Oona. I'll definitely come back to you in a minute with another question. But just before I turn to you, Maria, I hope you won't mind if I just come back to Mr. Kostin for a second, because I'm aware that the clock is ticking and he needs to leave in 10 minutes. So I'd just like to put a couple of the questions that we had in the chat box for him specifically. First of all, there was a question asking if you are cooperating with foreign investigators from allied countries and how you were doing this. And a second question asking what sort of evidence are you looking to gather for a future trial on aggression? Did you get those?
Yes, as far as I understand, first is about our cooperation with our colleagues from the allied countries. Am I right?
That's correct, yeah.
Yeah. We are grateful, and we have several for all assistance we received, not only technical and not only expert assistance, but also, as we say, the assistance on the ground. And we have several teams of our colleagues who worked shoulder to shoulder with our prosecutors and investigators, and even in quite dangerous conditions. And we are extremely grateful. This is a real signal of solidarity of all lawyers, I would say, who understand that that our fight for justice in this war should be also victorious, not only for Ukraine but also for the whole world. I will name the teams of experts which have been with us for the last year. Our colleague has already mentioned the team from Netherlands, and there were more than 40 forensics from Netherlands who worked in Ukraine and helped us with the collection and preservation of evidences collected not only by them but also by our investigators. I would also name the group of the experts from Spain, who just have been with us in November. 3 missions of field experts from France, of National Gendarmerie, with a full set of forensics and together with a unique mobile DNA laboratory which they granted to Ukraine and which now works in Kharkiv, close to the crime scenes. And their work was absolutely outstanding. We have also field missions from Lithuania and Slovakia. And if I miss someone, please just forgive me for this. The biggest problem is security restrictions, and we have requests actually and negotiated field missions from the other countries like Poland, but for security reasons they are not allowed to come at the moment. And I will also mention our joint investigation team together with our colleagues prosecutors from Lithuania, Estonia, Latvia, Poland, Slovakia, and Romania, in which we are investigating the supreme international crime, the crime of aggression. And I understand that there is quite a few time. Your second question was about evidences.
What sort of evidence?
Yeah. On the one hand, it seems that it's not very complicated because we have a lot of public positions by Russian top officials who initiated this war of aggression, starting from the Kremlin's leader Putin. And in order to collect all of the evidences, we use open source information. So as I mentioned, a lot of public statements. We are also looking for documents, orders, instructions, and decisions of the parliament, ministries, army, and president of Russia, in order to not only to collect these evidences, but also to analyze the potential chain of command between Putin and his entourage. And also the intelligence information, these are interceptions, visits of top level Russian officials to the occupied territories of Ukraine, video fixing of movement of Russian troops before aggression and at the beginning of the aggression, and their connection with public statements of Russian top officials.
Thank you, Mr. Kostin, for answering those questions. And I want to come back to you, Maria, to give you the floor. I mean, you're not an official. I mean, you're coming from a human rights organization, from civil society. So maybe you could elaborate the role that your organization is playing in this process, or the role of NGOs, civil society more generally in Ukraine, on the ground or elsewhere on this topic.
Thank you, distinguished participants. It's an honor for me to be in such a company with the General Prosecutor, Mr. Kostin, and Mr. Korynevych, Special Ambassador, and thank you for APC and our experts as well. I represent Human Rights Center ZMINA. Currently, I'm advisor to the Human Rights International Advocacy. I think it is also important to mention that human rights community of Ukraine, together with legal experts, have been investing a lot of efforts since 2015 to gather evidence, to document, to store them properly, to use them later for accountability mechanisms. And a lot of invisible work was done to establish trust between those survivors of gross human rights violations, alleged war crimes, and crimes against humanity since the occupation of Crimea and parts of eastern Ukraine. And I think Ukrainian experience in terms of institutional cooperation between civil society, human rights community, and state institutions such as General Prosecutor's Office of Ukraine, in particular Prosecutor Office of an Autonomous Republic of Crimea, established in exile, and also mission of the President of Ukraine in Autonomous Republic of Crimea and other institutions is quite remarkable, as human rights community and state institutions establish trust and collaboration, productive collaboration, which is a sign of reforms taking place in Ukraine as a democratic state. from human rights community, I'm especially proud from legal experts of the community who have been working a lot together with state to submit inputs to the International Criminal Court after the occupation of Crimea. And advocated also for establishment of special tribunals. So currently we are the one front line together with the state to advocate for accountability using various international accountability mechanism as well as national. You also probably heard about Ukraine 5 a.m. coalition's efforts. It was a effort to unite all human rights experienced organizations to document alleged war crimes and crimes against humanity since first days of the full-scale invasion. And those interventions are field missions, open source data, research, etc. So international human rights, as an international human rights advocate, I felt a lot of support from international community, and it was important in the beginning. However, sometimes I felt it is declarative. I realized that when we started together with the state to advocate on the establishment of special tribunal on the crime of aggression, we faced some skepticism on the background. I would say as a scholar that it was rooted in colonial history of some states, as well as security threats of those who are neighboring aggressor state, the Russian Federation. However, I believe we are overcoming this, and I think we also have to encourage more proactively to help establish a special tribunal on the crime of aggression. Other players of strong democracies such as Japan. Our civil society group just returned from Japan, visiting government and parliament, and talking to expert community as well as media experts. And now Japan will be a chair of J7, country which has also very sensitive history and is very eager to support Ukraine. So I think we can put more efforts to establish this good coordination between us. In terms of universal jurisdiction, from practical perspective, I would say that this work demands a lot of specific trainings of investigators on the ground. I unfortunately had to see sometimes very unprofessional approach when those Ukrainian survivors come into little towns in Europe were directly asked, like, have you been exposed to some tortures or sexual violence? I understand the proactive desire to help us to document properly all the cases, but there should be very, very considerate and sensitive approach to those who have been survived this violence and human rights violations. And it can't be, it has to be done properly. I see that there are a lot of also guests who are from media here. As from our work of ZMINA organization, we have ZMINA Human Rights Center have been always focused on enforced disappearances. Just an example, I can expose you to the information that from the very first day we were documenting and urging that it will be a wave of enforced disappearances, unfortunately, because Russia was using the same methodology as in Crimea and in Eastern Ukraine. So only our little organization with our capacity documented fully proved 425 cases, 209 allegedly disappeared, 200 released persons, 17 killed, including one who died in captivity, and 2 persons who died after they were released. So we can say that there were both female and male and children, all the regions that were influenced by war: Kherson, Zaporizhia, Donetsk, Luhansk, Kharkiv, Kyiv, Chernihiv, Mykolaiv, Sumy, Poltava. and different minorities as well, 7 Crimean Tatars, 1 member of Azov Bulgarian minority. It's only a little example of the work, which is quite specific, because we all knew that we had to properly document this case, to properly save the documents, to properly use all the evidences for them to be used either in national jurisdiction or in international accountability mechanism. And for recommendations to international community that support us, I would say that as I said, universal jurisdiction, the professionals, investigators who are not in the capitals of big cities, but are working on the ground have to be trained properly. Support of Ukrainian international advocacy, both for our state and civil society. What I mean in terms of the outreach to those states, for example, in the UN General Assembly, who usually vote abstain to the country-specific resolutions regarding Ukraine. We've been doing this outreach with ZMINA and Human Rights House Crimea in October regarding specific resolution on the human rights violations in Crimea. And we realized that some states have no idea what had happened in 2014. And we were providing a lot of information as well as historical background. Also, I think support of grassroots organizations that are doing invisible work sometimes to document, to establish this trust with victims, with survivors. And of course, involve civil society in the process of discussion on what form of the special tribunal on the crime of aggression will be established, because sometimes I feel we have a lot of discussion, but not really involved. And I thank you a lot for our government's effort to bring this topic of accountability on the most high limelight as possible. I thank you.
Thank you very much, Maria, for outlining the really important work that you're doing and giving us some really important recommendations. I want to put some of the questions that we have now in the box to some of the speakers before we come to the end. The first question I want to put is for you, Roeland. It's from Jep Funda, and he is asking, what is sufficient international political support for the Netherlands? I mean, he's talking about in relation to the creation of the special tribunal, because you'd earlier mentioned it would be created if there was sufficient support. So what does this actually mean in real terms?
Thank you very much for that question, which nevertheless, unfortunately, I'm not able to answer in very concrete terms. We leave it at that vague connotation at the moment, sufficient political and financial support. Ultimately, it will have to be a political decision by any interested member state, of course, but certainly also by my government as the projected host state. So I think I would make a mistake in mentioning now any numbers of states, even leaving aside that you have big states and small states, rich states and poorer states. So I'm not going to do that. But what we're doing as long as we're not there yet, we're trying to seek as much support as we can. And then there will be obviously there will be a moment when we feel it's time to take a step further. But I mean, this is not, of course, only done by the projected host state. For the whole decision taking, we need the international community. So I'm sorry, this is a vague answer, but I cannot be any more precise than that. But thank you.
No, it's okay. I mean, honestly, you'd think it would be a no-brainer because the size of the crimes that are being committed, I mean, they're so huge. And one would hope that you'd be able to get quickly the necessary political and economic will to move forward with this. So let's keep our fingers crossed that this happens sooner rather than later. I see you raised your hands, Nils. I mean, there's also a question here for you that maybe I can put in at the same time about the role of Eurojust as an operator of dedicated database to preserve and store evidence and how it relates with the plans of the special tribunal.
Yes, thanks a lot, Amanda. I will come to Eurojust question in a moment, just to follow up on what Roeland just said. Let's say both forms of the tribunal will require sufficient international support. That's clear. Whether you go for the international or the hybrid, both need sufficient support. They have different forms how to establish jurisdiction and how to overcome immunity. But at the end, the questions are very similar. And it is clear, and that is one point where Oona, our legal analysis is a bit different. We don't believe that the hybrid tribunal would immediately mean that the Russian leadership would be off the table, could not be prosecuted by the hybrid tribunal. Yes, let's say both tribunals would have to demonstrate that they overcome immunity. For the Rome Statute, it's written black on white. But the problem, Amanda and colleagues, let's say here we are stepping away from written legal rules. We are stepping into customary international law. And there you need state practice and opinion juris. And there it's becoming quite vague. And therefore, let's say, as Roeland said, there's no precise answer to the level of numbers. But you need a sufficient number. Let's say, for example, the last resolution for Ukraine was voted by around 90 members. Much below that, it will become difficult to establish a sufficient international character. But indeed, as Roeland said, let's be prudent with numbers. But the hybrid tribunal, if supported by a strong resolution by the United General Assembly, you could make the case that it gets an international character, like foreseen in the so-called arrest warrant case of the International Court of Justice, and therefore could prosecute the Russian leadership. It's a mix between how you interpret public international law and political will. At the end, it boils down to that. But that's very important to bear in mind. And that's why also at the Union, we are at the moment reflecting, as Roeland said, what way to take forward. We should, whatever way we decide, we should find a way that we have very strong international support in New York at the United Nations. On the question about Eurojust, yes, thanks for the question how to make sure that evidence collected by, like, for example, this eyewitness app is then brought to Eurojust and collected. Let's say Eurojust is supporting the prosecutors from those 6 member states plus Ukraine, the ICC, and also US is now cooperating with this joint investigation team. So in principle, best is to let's say, submit this kind of evidence to the prosecutors who then would feed into the Eurojust database. That's the normal way how this kind of data could be fed into Eurojust. Back to you.
So can I just add a brief word on this question of the—
Yeah, sure.
So I think it's pretty clear that if in order for a court not to have to observe personal immunities, it has to be an international court. Now, what is an international court? It has to be a court that's speaking on behalf of the international community. What exactly does that mean? Well, we know what does, but we don't know necessarily exactly what doesn't. We know that the Special Court for Sierra Leone, which was created through an agreement between the United Nations and Sierra Leone, was set up as a hybrid court, but was found to be an international court. If that was how it was done, if there was a hybrid court set up through the approval instead, through the recommendation of the General Assembly, then I think you're right that then it would clearly be could be an international court, depending on how it's structured. And that would not have to observe personal immunities. The version that people are talking about is a version that would be established within the Ukrainian domestic legal system. If that is how it's set up, it almost certainly has to observe personal immunities in the same way that the rest of the Ukrainian legal system has to, which means it couldn't go after Putin and other top leadership. Whereas there's no question the international court that is established through an agreement between the UN and Ukraine as an international court speaking on behalf of the international community would not have to observe personal immunities. Now, on the question of the political support, formally speaking, you need a majority in the General Assembly. I think, though, almost everyone thinks for this to really have legitimacy and kind of strength, you probably want more than a bare majority. Exactly what number is enough, that's a matter of judgment. The resolutions that have condemned the illegal aggression in Ukraine have received over 140 votes each. Now, it is certainly one thing to condemn and another thing to establish a tribunal that can try. Nonetheless, there has been support and recognition that what's happening is illegal. And fundamentally, what's being violated is a principle of the United Nations Charter, that is Article 2.4. That is the crime of aggression is the violation of Article 2.4. It makes sense for the UN to be the body that establishes it. So this is one of the reasons that, that at least I and a number of my colleagues are supportive of that approach.
Thank you, Oona. We had a question related to the ICTY, what lessons can be learned from the ICTY when we're talking about the special tribunal for Ukraine. I'm not sure who would like to answer that. Any takers? Yeah, Nils.
I can give it a shot, but let's say Oona is the expert on, let's say, the legal back. But let's say with the International Tribunal on Yugoslavia, there the situation was different to the current, at least for the time being, because you had a reference from the United Nations Security Council. And that, let's say, is one of the big questions which is also in the room. At the moment, the Security Council will probably not refer the matter to the ICC. By the way, if the Security Council referred the matter today to the ICC, we wouldn't have all this debate. But that doesn't look to be on the book. The Security Council also could, let's say, establish or call for an international tribunal, which then the United Nations could negotiate, for example, with Ukraine. The problem is here, it will not come to it. And therefore, the question is, could the United Nations General Assembly usurp, let's say, take that power that the Security Council had in the case of Yugoslavia? You can make the case under the Uniting for Peace resolution, but also that is not crystal clear. So that's precisely one of those questions. So in terms of setting up the tribunal, the pathway of the ICTY, so Yugoslavia, would not function here. We would have to use a fallback power of the United Nations General Assembly in terms of immunity. Of course, once you have the Security Council mandate, as Oona explained, then you can overcome immunity immediately. Again, as here you would use United Nations General Assembly power, you again have to make one step further. And therefore, the Tribunal for Yugoslavia is one of the precedents, but let's say it does not lead directly to a solution here.
Okay, do you want to add something, Oona?
Well, I agree with much of that. So I think the challenge here is that there are two lessons to learn. I mean, one is that you can set up a special court. I mean, that is a kind of distinctive, we've had some experience with doing that. I think we also learned a lot of lessons from it. One lesson we learned is we don't want something quite so sprawling. I mean, that lasted a very long time. It was very extensive. The nice, in a way, what's useful here is that we've already got the International Criminal Court, which is a standing institution that's set up to try crimes against humanity, genocide, and war crimes. This special court would have a fairly narrow mandate, which would be focused just on the crime of aggression and would likely be focused exclusively on the top leadership within the Russian government. And so you would have a fairly lean, mean machine, which would be distinctive, I think, from the ICTY, which was much more sprawling, much more extensive, spent a lot of time. And there was a lot of lessons about how to stand up a court, questions about, just structural elements that I think we've learned from the ICTY. So that's quite useful. But I agree that the specific path of having this mandated by the Security Council is just not available here, given the certain veto from the Russian Federation. So as a result, we have to look to alternatives, as already the UN has several times in working to provide support to Ukraine throughout this conflict.
Okay, thank you. I would just like to give, Anton and Miria a last chance to speak as well, because we run to the end. If you wanted to respond to anything you've just heard, or maybe you could also perhaps cite now what would be your biggest priority now, what you're going to be focusing your work on immediately within this key issue of setting up the tribunal to get it done as soon as possible.
Yeah, thank you so much, Amanda. It's a real pleasure really to listen to professional discussions, and it's always good to understand that really we are on the brink of all these developments, and I'm sure that we will get the job done. As of now, we are discovering all the options. All the options are on the table. We want to have as much international tribunal as it can be for it to be legitimate, credible, and for it actually to be a response from international community. But all the options are on the table. We are discovering them, and I'm sure that together with our partners, we will find the best, the most effective solution. I think that what we need is to really understand under which model we will be moving, and I think that it is worth understanding it as soon as possible, because we can go for a model ourselves, but it's important to have support of our friends and partners in that, for us not to suggest anything which will not fly. So this is the first issue, and the second issue I think important is, again, we are grateful to our colleagues from the European Union, in particular from the Commission, from DG Just, for this announcement on the ICPA, on the International Center for Prosecution of the Crime of Aggression. I think that this is really, as I mentioned, a very important first step, and I think that we need now to launch it fully. So I think that within several months, it's possible. So let's do that together. Let's do this step. And I'm sure that while doing this, we will find a way how to move forward with this special tribunal issue. I thank you.
Thanks to you, Anton. Now to you, Maria, for the last word.
Yes, I would like to thank you also, our partners and DG Just it's really a quick job, I would say, knowing the procedures in Brussels, and it is a high demand it's the biggest demand now of Ukrainian society itself for the accountability. However, we understand that it's better to invest more time in a proper model and make it all be easier later implemented than to be too fast. And also, as I mentioned before, the outreach for those countries who are still politically hesitating is very important, especially in terms of European, our member states allies, because they have a lot of influence, they have credibility to advocate together with us. It's important for us, and I thank you.
Thank you. So on behalf of the EPC and the US mission to the EU, I would really like to thank all of you for joining us today. I think we had a great discussion. I have to say, I certainly learned a lot from this. It's clearly a very complicated process, but I agree with, Anton, we have to get the job done, and we have to get the job done because millions of lives have been lost due to Russian aggression, and the world cannot once again just sit back and allow the Russians to get away with the aggression they have been doing, not just in Ukraine, but as I said earlier, in many other countries around the world. It's time for them to pay. So I really do want to see the political will, the money on the table, to take the necessary steps to bring these people to justice, to get them behind bars. Certainly the EPC will be continuing to follow this issue very closely in terms of events and publications. I hope that we can stay in touch with all of you, because I think you're all doing an amazing job. So congratulations for that. And as all our events on Ukraine have to end, we have to say Slava Ukraine on the road to victory. Thank you again, and I look forward to seeing you again in the future.
Героям слава. Thank you, Amanda, guests.